Imagine a gender-equal world, a world free of bias, stereotypes, and discrimination, a world that is diverse, equitable, and inclusive, a world where difference is valued and celebrated. Collectively, we can all break the bias. Good morning to one and all. I, Prachi Mishra, Assistant Professor of Law, on behalf of the Center for Human Rights and Humanitarian Law, Expire Law School, the Expire University, Dehradun, welcomes you all for the International Women's Day celebration. The entire event is approximately of 1 hour. The attendees are requested to keep themselves mute for the entire duration of the session. In case of any queries and questions related to the lecture, the attendees are free to post their questions in the chat box, which shall be taken up at the end of the lecture. A feedback form shall be circulated to you. Kindly fill the same for the participation certificate. Now, starting with the event, I would like to invite Brigadier Rajiv Sethi, the Registrar of the Expire University, Dehradun, for giving us a brief overview about the university and a welcome address. Sir?
Thanks, Prachi. And firstly, my welcome to Professor Richard, who's joining us from United States and is at around 10 o'clock in the night. And Prachi for organizing as well as taking care to make sure that the students are exposed to what women rights are and the various, what Women Day is all about. And I also would like to welcome, or rather I would say that I would also like to say that the Assistant Dean, Professor Kharola, Dr. Kharola has taken keen interest to make sure that this event is organized on the right day. That happens to be the 8th of March. As far as the ICFI University is concerned, we are ICFI Dehradun is part of 11 universities all over India. And we have 9 business schools as well. The ICFI Law School is one of the most vibrant schools of the ICFI group and boasts of a strength of approximately 1,600 students. We anticipate the student strength to be going even further in this year. As far as Women's Day is concerned, it is celebrated all across the world on the 8th of March. It started on 1911, so approximately 110 years back was the first day that was celebrated. And as far as India is concerned, we had our own pioneers during this, in the times who fought against women's discrimination. We had Raja Ram Mohan Roy, we had Dayanand Saraswati, who in the early 1900s, there was a lot of discrimination like Sati Pratha and all other things which were kind of, were not very, were very bad practices, and they took up cudgels to end these practices. And as far as the other issues are concerned, there have been, over the years of our independence, a number of initiatives have taken place. From the government side, something like Beti Badhao, Beti Padhao, Beti Bachao, Beti Padhao, etc. All these events have kind of tried to bring out the fact that we must have a sense of equality among both the sexes. And lately, in fact, the whole credit goes to the legal profession, wherein a large amount of equality has been granted. Recently, we had the property laws, equal property laws, and a number of other such initiatives have taken place. With that, I would like to request Prachi to take the matter forward. Thank you.
Thank you so much, sir. Now I would like to invite Mrs. Monica Kharola, the Assistant Dean and the Academic Coordinator of ICFI Law School, Dehradun, to give us a brief overview of ICFI Law School and the Center.
Thank you, Prachi. Am I audible?
Yes, ma'am, you're clearly audible.
A very good morning to everyone and a good evening to Professor Richard, who has been a kind professor coming all the way from Texas and willing to address our students on this important day of International Women's Day. And we thank Registrar Sir for introducing the topic and telling us how India has taken some steps towards preventing the disparity, discrimination in the social practices and also in the different fields in India. We have had, and not only India, it is for all over the world that we have had practices which have been discriminatory against women and have not given the opportunity for them to rise up to the status of the other sex, to contribute effectively to the national economy and to the development of the world. And as today the international bodies have become important, we have become a highly globalized world. So we are aware of all the difficulties that are faced by women everywhere, all over the world. So it is important that right from the constitutional practices, there must be empowerment by the state and through the different mechanisms that they have in order to see that there is empowerment, because this will lead to development of humanity as such. You cannot expect half the population to be unempowered and to still be able to develop internationally and nationally. And ICFI Law School, ICFI University, Dehradun tries to motivate its students and tries to encourage them to learn the different arenas and aspects of law which impact people. In this case, we talk about women as it is focused on the International Women's Day. Our Center for Human Rights and Humanitarian Law is a very upcoming center where we have Professor Prachi Mishra, who is working very hard to enhance its reach, and we have had where students continuously are working towards whether it is encouraging vaccination or it is encouraging rights of children and women. So the human rights cell is doing very well, and the student coordinators are also very effective and are very enthusiastic about making more impact through this center. It will include research, it will include work in the community, in the vicinity of the university, and it will also help in sensitizing the students and the community at large about the various problems faced by women. And of course, we have had very troubled times these days with political situations all over the world being impacted because of certain acts internationally. On this international women's rights, we want that through our guest speaker, we want to disseminate the information how America has contributed to bringing up women and giving up the discriminatory laws and making them equal participants in the development of their country. And I'm sure that India has also done a lot, and we will also be able to take our women further. That is important for national development and internationally for humanity to be more human and to be able to enrich ourselves as a community, as a world community. So thank you to Professor Richard, and over to you, Prachi.
Thank you so much, ma'am. Now, I would like to take this opportunity to introduce this esteemed speaker of the session, Professor Richard Albert. Richard Albert is Professor of World Constitution and Director of Constitutional Studies at the University of Texas at Austin. He has published over 20 books on democratic reform and constitutional values, including constitutional amendments, making, breaking, and changing constitutions. Oxford University Press, 2019. A graduate of Yale, Oxford, and Harvard, he is the co-president of the International Society of Public Law and the founding director of the International Forum on the Future of Constitutionalism. Sir, we are honored to have you with us here. Kindly accept a small token of e-gratitude from our end.
Thank you.
Thank you, sir. Now I would like to invite Professor Richard Albert himself to enlighten us with his intellectual thoughts. Thank you, sir. Over to you, sir.
Well, thank you. Thank you for your kind introduction. It really is a great pleasure to be with you today. My greetings and thanks to the Vice Chancellor, Professor Dr. M. Karan Singh, to the Registrar, Brigadier Rajiv Sethi. My thanks to the entire university, the law school, and to the Center for Human Rights and Humanitarian Law. Congratulations on these new beginnings for the center. Thanks especially to Dean Monica Carolla for this marvelous invitation to be with you today. Also to Professor Prachi Mishra and to the student organizers, Mr. Akshat Agarwal and Ms. Nitya. And of course, my thanks to all of you for being here today as we celebrate International Women's Day. It's a special honor for me, and I take this invitation as recognition for the initiatives I've taken to help bring us to at least gender parity in public law, and hopefully, preferably, to gender parity plus. I've made a commitment to gender parity in my role as co-president of the International Society of Public Law, and also in my capacity as director of the International Forum on the Future of Constitutionalism. And I've created the Academic Diversity Pledge to encourage scholars all around the world to participate only in those conferences whose organizers are committed to gender equality. I encourage all of us to do what we can to bring gender parity to the field of public law. On this day, I wish everyone gathered here a happy International Women's Day. There's been a lot of progress made around the world in the past generation, and that's great news. But lots of work nonetheless remains if we are to make real the promise of equality, a promise of equality for all, without regard to sex or gender. The state of politics in many countries around the world reveals some progress on equality. In 1960, only one woman in the entire world held the highest executive position in her country. By 2019, that number had risen from 1 to 18, a dramatic increase in the space of 60 years. Much higher, but still not high enough. We see similar positive transformations in health outcomes, socioeconomic status, and gender disparities. For example, since 1960, the Gender Equality Index rose in every single region of the world, from Africa to the Americas, from Eastern to Western Europe, and from the Middle East to Asia. And progress continues today. Another area where progress toward gender equality is unmistakable is in constitutions around the world. Countries have made giant strides on gender equality, so much so that today, the overwhelming supermajority of national constitutions explicitly guarantee equality or non-discrimination on grounds of sex or gender. And so you can see that the world has come a long way. But the march toward true equality must continue. And one country where there is a lot of work to do still is here in the United States, where I'm standing today. Would you believe that the United States Constitution, still today in the year 2022, would you believe that the US Constitution still today does not expressly guarantee sex or gender equality? This may come as a shocking surprise to many of you. To me, it is sad and upsetting. In my comments today, I'd like to explain to you why the 235-year-old US Constitution still does not codify a guarantee of sex or gender equality. And I'll tell you also about one important effort currently underway to try to change that. And the title of my remarks today is The Battle for the Equal Rights Amendment in the United States. Come back with me to the age of revolutions. France created one of the world's first early modern bills of rights in the year 1789. That Bill of Rights did not contain an explicit protection for gender equality, nor for sex equality, nor did it even mention women at all. In fact, the name of the original French Bill of Rights tells you all you need to know about the state of women's rights and gender equality at the time in 1789. Because the title of that Bill of Rights was the Declaration of the Rights of Man and the Citizen. The Rights of Man. That was the year 1789. 2 years later, in the year 1791, the new Polish constitution made no mention of sex or gender equality, nor even of women at all. And of course, the world's oldest enduring codified constitution, written in 1787 here in the United States, that constitution says nothing about gender or sex equality. Nor does the United States Bill of Rights acknowledge gender equality. That document was enacted in the year 1791. That's over 230 years ago. And still today, nothing in the US Constitution speaks explicitly of a general pledge of gender and sex equality. This makes the US Constitution an outlier in the world. It is one of the rare examples of constitutions presently in force that does not expressly protect the fundamental norm of gender non-discrimination. If you look at all of the world's constitutions, and there are many of them, over 175 of them guarantee equality without regard to sex or gender. Pick almost any country you know, and it's likely that its constitution protects against gender or sex discrimination. Let's start with the letter A, for example, Algeria. The Constitution of Algeria declares that, quote, there shall be no pretext for discrimination on the basis of gender. What about the letter B? The Constitution of Bangladesh says that, quote, the state shall not discriminate against any citizen on grounds only of sex, end of quote. We can continue down the list throughout the entire alphabet, even to C, to Canada, my home country. There, the Constitution of Canada pledges that, quote, every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination based on sex. I could go on, but you get the point. There are over 175 constitutions in the world that make very clear commitments to sex or gender non-discrimination, including your constitution, the Constitution of India. Your constitution expressly prohibits discrimination on grounds of sex. Article 15.1 declares that the state shall not discriminate against any citizen on grounds only of sex. Article 15.2 continues, no citizen shall, on grounds only of sex, be subject to any disability, liability, restriction, or condition with regard to access to shops and public accommodations, the use of wells, tanks, bathing ghats, roads, places of public resort. And then there is Article 15.3, which in my view is very, very special. Here's what it says. It says, quote, nothing in Article 15 shall prevent the state from making any special provision for women. In other words, the Indian Constitution provides for affirmative action to help support women, to bring women to a positive position in society of parity and equity after years of non-equity and non-parity. This, I think, is an important constitutional protection that we see in the Constitution of India. And it's one that much of the world should learn from, because India's constitutional designers were very well aware of the importance of expressing in the text of the Constitution the value and the importance of sex and gender equality. And so the overwhelming number of world constitutions protect gender equality, and that's an enormous victory for non-discrimination. It was not always this way, however, because constitutions did not always protect gender equality, and only relatively recently have constitution makers done the right thing by codifying the gender non-discrimination norm in their constitution. But there is no similar constitutional protection that exists in the United States. of all places, home to the world's oldest constitution currently in force, a constitution that's been a source of inspiration for liberal democratic states around the globe, the US Constitution does not expressly guarantee sex or gender equality. And that's not because of any lack of effort, because many have tried to codify the gender non-discrimination norm in the US Constitution. It's just that so far they have all failed. That may soon change, however, with an effort currently underway to amend the US Constitution to insert a protection for sex equality into the Constitution. Let me tell you about that effort. And the story begins in the year 1972. That's 50 years ago this month. In 1972, the United States Congress adopted an amendment proposal to put gender equality into the text of the US Constitution. That amendment proposal was known as the Equal Rights Amendment. Equal Rights Amendment. After it passed the Congress, the proposal for this Equal Rights Amendment was then sent to the states for their consideration, whether to ratify it or not, as the 28th Amendment to the US Constitution. Here is the text of the Equal Rights Amendment in relevant part. Equality of rights under law shall not be denied or abridged by the United States or by any state on account of sex. That is the Equal Rights Amendment, Section 1. And it was sent to the states for ratification in the year 1972. Now, those of you who know about the US Constitution probably know that amending the US Constitution is not an easy task. It's very difficult. And the proof is in the number of constitutional amendments that have been enacted in the 235 years since the Constitution came into force. There have only been 27 amendments in those 235 years. 27, 235. That's not a lot. It's many, many fewer than the 100 plus amendments that have been made to the Indian Constitution since it came into force on January 26, 1950. In the US, it's very hard to amend the Constitution because of the amendment procedure. An amendment requires the approval of 2/3 of both houses of Congress, as well as the ratification of 3/4 of the states. 3/4 of the states is a lot because there are 50 states. And so that means that we need 38 of those 50 states to ratify an amendment proposal. It's very difficult, very, very difficult. Okay, so back to the Equal Rights Amendment. When Congress approved that amendment and sent it to the states for their ratification, Congress imposed a 7-year time limit for ratification. This meant that states would have 7 years to ratify this amendment. And after that period of time had elapsed, at the end of 7 years, the amendment would expire and could no longer be ratified. It's important to say here that the 7-year deadline imposed on the Equal Rights Amendment in the year 1972, that deadline was not out of the blue. It was not uncommon. It had historically been the ratification deadline used for amendments, for every single amendment since the 20th Amendment proposed and ratified in the 1930s. And so the 7-year time limit was not seen as unusual, nor as an inappropriate constraint on the power of states to ratify it. And so because Congress approved this amendment proposal in 1972, this meant that the deadline to ratify was 7 years thereafter, in 1979. And remember, the rule for ratification is that 38 out of 50 states must agree in order for the amendment to become valid. So the magic number is 38 states. So once this Equal Rights Amendment was sent to the states for ratification, things looked quite promising because within 1 week, 7 states had ratified the Equal Rights Amendment. And then within 1 month, 14 states had ratified it. And then within 1 year, 30 states had ratified the Equal Rights Amendment. 30 states is just 8 states fewer than the magic number of 38 required for ratification. And so there were 30 ratifications after 1 year, and 6 years left to secure the remaining 8 ratifications in order to enact the Equal Rights Amendment as the 28th Amendment to the US Constitution, and finally to guarantee sex equality in the text of America's Constitution. And so you can imagine, many people were very excited in the year 1973, with 30 states having ratified the amendment within 1 year of its proposal to the states. But something happened. Something happened in the following 6 years. In the subsequent years, only 5 additional states ratified the proposal. And so this brought the number of ratifications to 35, 3 fewer than the required supermajority of 38 states needed to amend the Constitution. And so what happened? Well, supporters of the Equal Rights Amendment became increasingly worried that they would not reach the 38 state threshold before the 7-year deadline. And so as the 7-year ratification deadline approached, and as it seemed increasingly unlikely that 3 more states would ratify the amendment, Congress passed a resolution extending the ratification period for another 3 years. And so the deadline to ratify would no longer be 1979. It would now be 1982. And so Congress simply extended the deadline. Okay. Now the story does not have a happy ending, because although Congress extended the deadline to ratify the Equal Rights Amendment by 3 years, from 1979 to 1982, although Congress did that, by the end of the new deadline in 1982, after an additional extension, the Equal Rights Amendment had failed to be ratified by the 38 states required to officially enact an amendment. And so even with the ratification extension, even with the support for the Equal Rights Amendment across much of the country, even with the support of the Congress, in the end, the amendment failed. There was great disappointment from many corners in the United States about the defeat of the Equal Rights Amendment, because years of effort, years of strategizing, years of lobbying, years of praying, there was nothing to show for any of it, because the amendment had not been ratified by the deadline. And that had been the goal all along. The result was that in 1982, the Equal Rights Amendment was dead. Or so it was thought. Because today, in the year 2022, some believe that that Equal Rights Amendment has been duly and properly ratified, and that it is now, today, the 28th Amendment to the US Constitution. If you're confused, that's okay, because there's a confusing sequence of events still to be described to you. How can an amendment proposal that is thought to be dead, expired in 1982, today in 2022, how can that same amendment proposal be thought by many to be ratified? Well, the answer is that since 1982, 3 additional states have ratified the Equal Rights Amendment. Nevada in the year 2018, Illinois later in the same year, and Virginia most recently in the year 2020. All 3 ratifications came after the 1982 ratification deadline. But here's the interesting thing about all of this, is that there's a debate today in the United States on whether those 3 ratifications are valid. and whether the Equal Rights Amendment should today be recognized as the 28th Amendment to the US Constitution. That is why today there is a battle, a heated battle, over the Equal Rights Amendment in the United States. And let me explain to you the key parts of this battle. And I want to explain to you the key parts of the battle with reference to 3 questions. 1, does an amendment proposal ever expire? 2, can a state revoke its ratification of an amendment proposal? 3, can a constitutional amendment be unconstitutional? Let's begin with the first question. Does an amendment proposal ever expire? The text of the US Constitution is silent on when amendment proposals must be ratified. The constitutional text does not impose a time limit for ratification. And so the silence of the Constitution on this question has raised an important question. How long may a state take to ratify an amendment proposal? Congress, as you know, as I've mentioned to you a moment ago, Congress has, in the modern era, imposed a 7-year ratification deadline on amendment proposals. It's an option that the Constitution leaves open by its very silence. It so happens, however, that in American history, there's an example of an amendment that took a very, very long time to be ratified, 200 years, in fact. And that's the 27th Amendment. It was ratified in 1992, but that was well over 200 years after Congress first approved the amendment and transmitted it to the states. This 200-year period was possible only because the Constitution does not require lawmakers to respect a certain period of time for ratification. The Constitution is silent on that point. So if you come back to the first Congress of the United States in the year 1789, James Madison proposed an amendment in this first meeting of the Congress. And here's the text of the amendment. No law varying the compensation for the services of senators and representatives shall take effect until an election of representatives shall have intervened. Now that proposal by James Madison was approved by both houses of Congress by the required 2/3 supermajority, and it was therefore sent to the states for their ratification. By 1792, 6 states had ratified this amendment. And then a 7th state ratified it in the year 1873. But then that was it. Only 7 states ratified it in the first 80 years after its proposal. It wasn't until 100 years later, in the year 1978, that a 9th state ratified this amendment proposal, the same proposal that had been issued in 1789. And so this revival of the amendment subsequently led another 30 states to jump aboard in the next 14 years, so that by the year 1992, Michigan became the 38th state to ratify the amendment, and that brought the country to the 3/4 threshold required to ratify the amendment. And so you see here, this amendment took 2 centuries to ratify. But despite taking that long to ratify, Congress had no problem with it. The executive branch had no problem with it. And the federal courts did not have a problem with it either. And so today, when you look at America's codified Constitution, you will see that the text includes the 27th Amendment ratified in 1992, but originally proposed 2 centuries prior in 1789. That amendment is valid to the full extent of the law. And that is an important precedent. Because today, there are 4 other long-standing amendment proposals awaiting ratification. Each of them has been approved by the House and the Senate, and now each is in the states for their consideration. This long interval in the United States between proposal and ratification raises a question. And the question is whether an amendment without a ratification deadline ever expires after a significant period of time. And the answer from political practice is emphatically no, in light of our example of the 27th Amendment, which was ratified 200 years after its proposal. All of this, of course, is related to the Equal Rights Amendment that protects gender equality. But the Equal Rights Amendment raises a related but different question, which is, what if the amendment proposal itself contains an expiration date? Does that trump the silence of the Constitution? Are states bound by that expiration date? And does it matter if the deadline for ratification is written in the resolution authorizing the amendment versus in the text of the amendment itself? These are the key questions at the center of the battle over the ratification of the Equal Rights Amendment today. So that's the very first big question about the Equal Rights Amendment today. I mentioned to you that there were three questions. Let me now go to the second of the three questions at the heart of the battle over the Equal Rights Amendment. Here's the question. Can a state revoke its earlier ratification of an amendment proposal? The Constitution is silent on whether a state can revoke its prior ratification of an amendment proposal before the amendment proposal becomes officially enacted. Here's why this is a question. This is a question because since the Equal Rights Amendment was first proposed in 1972, there have been 6 examples of states revoking their prior ratification of the amendment proposal. And so if a state can validly revoke a prior ratification before the amendment becomes official, this would mean that an insufficient number of states had ever ratified the Equal Rights Amendment. And remember, the magic number is 38. And so if there are 38 states that have ratified, but 6 have revoked those ratifications, and all 6 of those are valid, then that means that there are only 32 ratifications of the Equal Rights Amendment. But if a state cannot validly revoke a prior ratification, then the question becomes whether the 3 new ratifications since 1982 are valid. Because those 3 ratifications came after the expiration of the amendment proposal. And if those 3 post-1982 ratifications are valid, then the US has reached the magic number of 38. But if they're not valid, then the US still stands at 35 ratifications, which is 3 short of the magic number of 38. So that is the second major question today about the validity of the Equal Rights Amendment. There's one more question that is at the heart of the battle over the Equal Rights Amendment in the United States. Here it is. It's a question that is familiar to you in India. Can a constitutional amendment be unconstitutional? In India, courts invoke the basic structure doctrine to declare amendments unconstitutional. And we see this happening in a growing number of countries around the world. The Indian Supreme Court first declared in 1951 that the power to amend the Constitution was unlimited. But then the Indian Supreme Court interpreted the Constitution as authorizing the court to invalidate amendments that violate the basic structure of the Constitution. The organizing logic of this basic structure doctrine is that every provision of the Constitution can be amended, provided that, in the result, the basic foundation and structure of the Constitution remain the same. And those are the words of the Chief Justice in the Keshavananda case. The court has since defined the basic structure as consisting of various principles, including constitutional supremacy, the Republican and Democratic forms of government, the secular character of the state, the separation of powers, and federalism. And after having introduced the basic structure doctrine, the court has since invoked it to invalidate constitutional amendments in India. We've seen similar occurrences in other high courts around the world, in Belize, in Colombia, in Taiwan, in Turkey, and elsewhere. But this doctrine of an unconstitutional constitutional amendment, the basic structure doctrine, that has not taken root in the United States. US federal courts do not have an equivalent of the basic structure doctrine that authorizes them to strike down an amendment on substantive grounds. We know this because the US Supreme Court has had the opportunity to exercise this extraordinary power to invalidate an amendment, but the court has declined on every occasion. And in the process, the court has adopted a process-based approach to determining the validity of a constitutional amendment. And so for the Supreme Court of the United States, as long as a constitutional amendment adheres to the procedural rules for amendments specified in the Constitution, that amendment is valid and it is binding. And there are many cases that deal with this issue in the United States, most notably on the 18th and 19th Amendments. Both of them were subject to claims of unconstitutionality. Both passed and ultimately became inscribed in the text of the US Constitution, and claims against their constitutionality failed because the Supreme Court rejected those claims. The court looked to the process of the change, and the court ruled that the amendments had been properly passed as a procedural matter, and that was enough to make them constitutional. Now, this is where it becomes very interesting for the Equal Rights Amendment, because there's no question about the substantive constitutionality of the Equal Rights Amendment. There's no problem with its content. The questions about the Equal Rights Amendment are all about the procedural correctness of ratification. 1, can Congress impose a ratification deadline on an amendment? 2, can a state ratify the amendment after its ratification deadline expires? 3, can a state revoke its prior ratification? You see just as clearly as I do that these questions are all procedural questions. And the US courts could quite conceivably choose to answer them because they deal with procedure. US federal courts are reluctant to engage in questions involving the content of a constitutional amendment, but not the process of amendment. All of which is to say that the power of US federal courts to review constitutional amendments in the United States, that will be a question of great significance as the battle over the ratification of the Equal Rights Amendment continues in the weeks and months ahead. It is possible to envisage the US Supreme Court ultimately declining to hear the case, because the court might say, well, the amendment process raises a political question, and we have a political question doctrine, and that doctrine counsels courts not to hear disputes that are best resolved in the political process. And so the court might well say that and just decline to hear any claim that the Equal Rights Amendment is procedurally unconstitutional. Yet, it is perhaps just as possible to imagine the US Supreme Court ruling on the constitutionality of the Equal Rights Amendment. Here, the court would limit its judgment to narrow procedural grounds about proper and improper revocation and ratification. And so the bottom line here, in either case, no matter what the US Supreme Court does, is that in either case, it may well ultimately have to take a position on the Equal Rights Amendment, whether by declining to hear the dispute about its constitutionality, or perhaps by ruling that it is valid or that it is not. And in the process of all of this, we may see the emergence of an American doctrine of an unconstitutional constitutional amendment, joining India as one of the courts in the world, one of the high courts in the world that enforces the constitutionality of the constitutional amendment process. The battle over the ratification of the Equal Rights Amendment is important. It's important for the United States, and it's important for the world. It's important for the United States because the US Constitution is one of the only remaining constitutions, few remaining constitutions, that does not codify a guarantee for gender or sex equality. That guarantee is long overdue. And whether it comes in the form of the Equal Rights Amendment or in some other way, it must come. And it must come sooner rather than later. And the battle over the ratification of the Equal Rights Amendment is important, moreover, for the world. The overwhelming number of world constitutions that protect gender equality, that's an enormous victory for non-discrimination. Of course, it was not always this way. Early constitutions did not protect gender equality. It's only relatively recently that constitution makers have done the right thing by codifying the gender non-discrimination norm in their constitutions. To close, the world is moving in the right direction, and it's important to keep moving in that direction with the codification of gender equality in the US Constitution and in the few remaining world constitutions that do not yet protect gender equality. It is well past time to make the gender non-discrimination guarantee a global norm that transcends boundaries, regional, social, cultural, political. Time to make it a global norm that exists in every country of the world. And on this day, on International Women's Day 2022, it is the very least that we can do to help advance equality and to express our collective commitment to gender equality. Let me now pause just for one moment to once again say thank you. My greetings and gratitude to the Vice Chancellor, Professor Dr. Ram Karan Singh, and also to the Registrar who is here with us today, Brigadier Rajiv Sethi. Thank you for hosting this program. Thank you for your presence. My thanks and gratitude to Dean Monica Carolla for so warmly inviting me to participate in this important program on this important day. And my thanks also to Professor Prashi Mishra. Thank you for your generosity and for your assistance, and also to the student organizers, Mr. Akshat Agarwal and Ms. Nitya. And again, also to all of you, to all the attendees, for being here today as we join together to celebrate International Women's Day 2022. Thank you. And let me do one more thing. I'm always interested to hear from and to meet scholars who are working on questions in constitutional law and democracy. Here is my contact information if you wish to be in touch with me. And let me also share with you a book. This is a book that I've written on a theory of constitutional amendment. Here it is. And I've put it in the chat. I believe you should be able to download it. And I welcome any comments you may have on it or any other subjects of mutual interest. Thank you so very much for this invitation.
Thank you so much, sir, for such an informative, interesting, and intellectual session. I'm sure that attendees had an amazing experience and must have learned a lot about the United States status, its standing on gender equality, and the role of equal rights amendments. So you have explained us the entire concept in such a simple and storytelling form. I'm sure the attendees must have enjoyed the same. Thank you so much, sir, for such an excellent session. Sir, there are a few questions from the side of the participants. With your permission, can we address them?
Absolutely, I'd be happy to do that, please.
So the first question from one of the participants is, Would ratification of the Equal Rights Amendment erase the present existing inequities that in the country, in the United States, given the fact that no law would be removed with the ratification of this amendment?
This is a very important question, because those who are debating the Equal Rights Amendment right now are talking about what the effect of the Equal Rights Amendment will be. So it's this very same question. What happens the day after the amendment comes into force? What does it change? Well, one thing that it changes is that it will probably do a lot to help with the gender wage gap. In the United States, the average male makes more money than the average female doing the same job. This Equal Rights Amendment will help to stop that, because states will be able to enforce an equal pay law. Congress will be able to enforce an equal pay law, and there will be sanctions attached for violating equal pay rules. Now, the Equal Rights Amendment doesn't mean, it will not mean that employers have to pay the same wage to everyone. All it will mean, and this is important nonetheless, it will mean that if there is to be a distinction made, if this person is to make more than that person, and the difference has to do with a number of factors, gender, age, whatever, if the difference is attributable to gender, the employer will have to give a reason why there is that difference in the gender pay gap. And the employer will have to give a compelling reason why that is so. It'll be very hard for the employer to do that. And so in my view, I think that the Equal Rights Amendment will change a lot for the good. It will also have an impact on a woman's right to procure an abortion. So I do think that the Equal Rights Amendment will have a huge impact in the United States, not only when it comes to the enforcement of the law, not only when it comes to political relationships, but also social relationships. Here's what I mean by that. If you read the text of the Constitution today, it refers only to he or him or his. There's no reference to she, to her, or hers, nor to they, their, or theirs. It's all to he, him, or his. The Equal Rights Amendment will tell you that that doesn't matter, that no matter the gendered language in the Constitution, you should not be dismayed by that, because the 28th Amendment, the Equal Rights Amendment, will confirm that men and women are equal, that there is no inequality under law between or among the sexes. So I do think it's going to have a big impact on the country.
Thank you, sir. So the next question is, given the broad language of the Equal Rights Amendment, the judiciary would have the power to interpret the same. This act somehow indicates an indirect power of lawmaking to the judiciary. Don't you think this would erode or somehow disturb the theory of separation of power?
Another very interesting question. In the United States, the judiciary has the power to invalidate laws or actions by the other branches of government. And so the power of constitutional review, of judicial review, is firmly ensconced. There's no getting rid of that. And so the Equal Rights Amendment will just be more of the same, just more for the court to interpret, consistent with its present role as the ultimate interpreter of the Constitution. So there'll be no additional powers given to the court. Nothing changes. The only thing that does change is that now the courts have the responsibility to ensure that all actors, private, public, respect gender equality.
So there are two more questions, but those two questions are not related to equal rights amendments. They are somewhere related to gender equality. So would you like to address them?
I don't know what they are, but please maybe give them both at the same time, and I'm happy to offer some thoughts in response.
Okay, sir, should I address them to you?
Please.
So there are various terms that are used when we talk about equal rights, like gender equity, gender equality, women empowerment. So how are these terms different, and is there any correlation that exists between them? This is the question from one of our participants.
That's the first one. And what's the second one?
So the second one is, when we talk about gender equality, our first reflex goes to women's rights and status. In this process, there are times when we often overlook the gender as an aspect of men's social identity. I would like to know whether Equal Rights Amendment would help to create an actual gender neutral environment.
Thank you for both of these questions. The first question has to do with the relationship between gender equality and gender equity. Very interesting question. Sometimes when you treat persons equally, you're not treating them fairly. Much better to treat them equitably in order to treat them fairly. Let me give you an example from the United States. There is such a thing as affirmative action in higher education, okay? So because of historical injustices perpetrated against African Americans in the United States, Blacks in the United States, many universities, many states have put into operation affirmative action programs that admit students who have been historically disadvantaged, who come from a lineage that's been historically disadvantaged, in order to make up for earlier wrongs against them and their ancestors. Now, in doing that, they're treating applicants differently. One applicant is not treated the same as another because one gets a special dispensation in light of prior wrongdoing against this historically wronged and underrepresented group in American society. This differential treatment, however, is fully legitimate. This is treating persons equitably, even though we're treating them differently. And so the Equal Rights Amendment will do both. It will just depend on the context, because sometimes it is wrong to treat persons of different sexes similarly. The Supreme Court has recognized this. Now, we have to treat persons equitably, fairly, without regard to any hint of objectification of the person. Everyone is an individual. She, he, or they must be evaluated as such, as individuals, not as objects. And so the Supreme Court has told us, of the United States, has told us that we can treat persons differently if the goal is to treat them fairly and justly without objectifying them. So the relationship between equality and equity is a complicated one, but the bottom line is sometimes in order to treat persons equitably, fairly, we must treat them differently. The second question was about gender neutrality. You know, this is something that we're reading a lot more about these days, gender neutrality. I am not sure where the law is going to take us on gender neutrality in the United States. I'm really not sure of that. We'll have to just see what the courts say when they're confronted with legal disputes that bring to bear that question. One case that I'm thinking of right now as I think out loud is a case of gender neutral bathrooms and restrooms. We see these increasingly in American society. There are some pockets of resistance across the country where some state actors, some interest groups will say, no, we must keep the sexes, the genders separate in their own bathrooms, as has been done historically. Others are resisting that. Others are saying, well, hang on a second. Why would you treat the genders apart? That evokes memories of racial segregation. Why not just treat everyone equally in this way? Gender neutral bathrooms is a controversial question. in the United States. And it's one on which the country has not yet arrived at a resolution. And so this is one that's still very much in progress. And so I invite you to keep up to date on the debates that you see happening in the United States.
Thank you so much, sir, for patiently answering the queries of the attendees. It was a pleasure to have you and hear from you. Thank you so much, sir, for giving us your valuable time. Now, I would like to invite Mrs. Monica Kharola for the vote of thanks. Ma'am.
Thank you, Prachi. And we have heard Professor Richard Albert, who has explained very nicely the concept of this Equal Rights Amendment in USA and how USA is trying to promote equality among sexes and how the different states have been supporting it, and in the long run, how it will help in bringing about equality among both the sexes. The Indian laws are also effectively promoting equality, not only in terms of Article 15, which Professor Richard has already explained very well, but also the other national laws in terms of the labor laws and other laws for protecting women's health and for protecting their wages, for ensuring maternity leave and all those rights. India is also making and trying to do its best in order to ensure that the rights of women are protected in India. We are today more clear about how America, through this lecture, is trying to bring about that equality among sexes. And we thank Professor Richard for being with us. And I'm sure that from today onwards, you'll be one of the Expire family, which has around 11 universities in India. And we'll always be looking forward to you to encourage our students to be motivated to work on international platforms, because the students of the coming days who are going to become leaders, they have to be aware and conscious about the rights of groups who need to be protected and ensured that they are supported so that they can contribute effectively to the health of all the countries. And I told you in the beginning, I'm a big believer that as a world we are one. We must work together to ensure equality and prevention of discrimination anywhere that it is. ILO has also played a very constructive role right from 1919 in order to ensure that working women also get their right shares and they are also protected. So it's been a wonderful lecture, and we are sure that the participants have benefited immensely in the sense that they are now clear about this Equal Rights Amendment, and they will be able to debate it and take that discussion further, be able to write and research on it more so that their capacity also is enhanced. And on behalf of the cell, I thank Professor Richard Albert for taking out his time and contributing to this learning process worldwide. I would also like to thank Registrar Sir for encouraging and motivating us always in order to ensure that we bring good lectures, we help in contributing to the growth of intellectual capital of the students and also exposing them to international opinion. So thank you, sir. And I thank the Vice Chancellor in absentia for strengthening the system to make it more effective and to make, as he says, education must be internationalized. That is his focus. So we thank him in his absence. And I thank Professor Prachi for doing the hard work in contacting Professor from Texas and making this lecture possible. So thank you to you and your team, Akshat Agarwal and Nitya, for working hard and making this human rights cell effective. There are many areas today where you can more explore, for example, the humanitarian law is today facing crisis and we must work on it. So looking forward to very constructive lectures and activities. And I thank Professor Richard Albert once again for, for being such a great help and encouraging us to take these activities forward. So thank you, and thank you, Registrar Sir. Over to you, Prachi.
Thank you, ma'am. Thank you so much, sir, for your valuable time. Now, with your permission, sir and ma'am, can we close the session?
Registrar Sir.
Well, thank you very much. I'll just say one more word. Two things, actually. One is I was moved by Dean Carola's call to the students here to engage with the world, to learn about what's happening in the world, because you are all leaders in formation, and leaders in formation will have to know about the world. And so let me introduce you in the link to the International Society of Public Law, which is the world's leading learned society for the study of public law, administrative law, constitutional law, international law. Every year we hold an annual conference. This year it's going to be hybrid, in person and online. And we invite you to join us. If you'd like to join us in person, you're welcome to. If you'd like to join us in hybrid mode online, you're welcome to. I've linked to the announcement about the conference, so please have a look. The deadline for submissions is March 15th. So that's in about 8 days, 7-8 days. So please have a look. And the second thing is just to reiterate my thanks to all of you for this wonderful invitation, and to wish great luck to the center and the work that you are all doing for the center. So thanks once again.
Thank you, sir. Sir, ma'am, can we close the session now?
Thank you. Yeah, I think we can.
Thank you, sir. Thank you.
Thank you. Thank you, Professor.
Thank you.